the three grounds advanced in support of the objection to bail or bond in the context of the four discussed statutory considerations and grounds, plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately, the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offenses unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the states of interference of witnesses and exhibits can be addressed using alternative means in lieu of the drastic step of denial of bond or bail. Wherefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the first accused bail or bond. Question B, whether the evidence which was gathered from the first accused's residence situated in Milimani area within Kitale was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the Locus Classicus and Arita Carini case, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a liturgy of cases. Further, this is a question capable of determination in another forum separately. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A, that pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B, that the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing 2 suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C, upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Roman 1, that the first accused undertakes not to interfere with witnesses and or evidence. Roman 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3, that the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4, that in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5, that the first accused undertakes to appear before court as and when required. Roman 6, that the first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention or hearing unless exempted from attending court physically. Roman 7, that in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8, that in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9 is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision which can be read by yourselves.